So welcome everybody to the program. My name is Marty Schenkman, and I'm joined by my colleague Jonathan Blotmacher, and in particular by our colleague Paul Hood, who I must acknowledge has done the yeoman's task on this program. And I'm certainly thrilled to be here and help Paul and Jonathan talk about a topic that is really critical to everybody's practice. Blended families are the norm, not the exception, and they raise lots of issues. Before we get started with that, just a couple of quick points. The PowerPoint will be available for you to download throughout the webinar. Just go to the handout tab, open it, and you can download or print it. There will be a recording of this posted to Schenkman Law. I believe Peak Trust and Interactive Legal ILS will also post it to their websites, along with all materials. We do not give out CLE or CPE credit. As noted in the advertising, you will get a certificate of attendance if you can self-report. And if you have any questions, please email us. Our email addresses should be available. Don't post the questions through the GoToWebinar console. It's just much more difficult to deal with. We'll skip the disclaimer. And first, a quick word from Vanessa Kanega, President of Interactive Legal, one of our sponsors.
Well, thank you, Marty, and thank you to the panelists for presenting today, and thank you to everyone for joining this webinar. It's always, ILS is always happy to sponsor these webinars, especially on a topic like this one that, as Marty mentioned, is something that basically all estate planning attorneys are now going to be dealing with a lot. So if you'd like more information on Interactive Legal, you can visit our website. And as Marty mentioned, we do have recordings of this. We will have this webinar, and we do have recordings of past webinars on our website available as well. We provide automated drafting solutions for elder law and estate planning attorneys. So if you'd like more information, you can also email our sales email address that you see on your screen. And thank you very much. Have a good webinar.
Thank you, Vanessa. And one of our other sponsors is Peak Trust Company. Let me just say, my personal perspective when dealing with complex blended families, which is a large portion of our clients, my preference is to name an institutional trustee where you have the independence and the professionalism that you don't get with Uncle Joe and Aunt Jane. It can be a single simple step to diffuse many complex issues. Nicole?
Yeah, thank you, Marty. Welcome, everyone, and thank you for attending today's webinar. I'm Nicole King. I work at Peak Trust, and as Marty was saying, we offer a full spectrum of trustee services for families. They're trusted advisors and offer flexible and administrative services for all types of trusts. We're currently located in 2 of the top tier trust jurisdictions, Alaska and Nevada. And this summer we have exciting news. We will be expanding to Delaware. So I invite you to take a look at our website. And if you have any questions, feel free to reach out and speak to any member on the team. Thank you.
And final comment, I try each webinar to feature a different charity. I think it's important that we all try to do good. It also gives us knowledge of good charities that we can recommend to clients when we get involved in a charitable discussion. And I think that's something that we should all be comfortable doing because giving back is so important. So Michelle is going to make a quick comment on a charity I've been very active with, the American Cancer Society. Michelle?
Yes, thank you so much, Marty. And yes, the American Cancer Society is the leading cancer organization funding cancer research, providing patient services, efforts in prevention and early detection and advocacy. And one of the ways we fund our mission is through wonderful, generous donors who do include us in their estate planning. And we work with a number of estate planning allied professionals around the country, in particular through our National Professional Advisor Network. As Marty mentioned, he's been a wonderful leader for us, and his support has made a huge impact. So we are nationwide. We can connect you with your local plan giving director, but we provide free resources for both you and your clients around different legislation affecting charitable giving, providing webinars, different tools to help you with that planning. So you can go to cancer.org/NPAN to join, or for more information. Marty can certainly connect you with us as well if you have any questions or have someone who's been recently diagnosed with cancer. Anything that we can do to help, we're there to be a resource. So we invite you to be a part of NPAN, and thank you again, Marty, for this opportunity, and have a wonderful webinar.
Thank you, Michelle. So let's get started. I'm going to drive the slides. So Paul Hood is going to be our primary speaker, and Jonathan and I will be the backup singers commenting as we go. So Paul, take it away, and if I don't move a slide fast enough or too fast, just yell at me. It's okay.
All right, thank you, Marty, and I certainly appreciate the invitation to join you two. August, this is a situation similar to, I remember an experience when I was at LSU, when I went and saw Shana Na, and Shana Na was opened by Sam and Dave, and I was sitting there thinking, as a kid, you know, in central Louisiana, Stax Records out of Memphis was huge. Otis Redding, Sam and Dave, and to think that Sam and Dave were opening for Shana Na when it really should have been the other way around. And in this case, the backup singers outshine the lead here. But what we're going to talk about are some of the really.
I got a little worried. I thought you were going to start singing the webinar instead of speaking.
No. I know, you know, I have a face for radio, and I know better than that. But blended family planning is not only hard to do, but it presents a number of bogeys in the path for estate planners, particularly on the ethics side. And you know, there are just some things that are different about when you get into the area of blended family planning, which is really relationships squared. We're going to talk about, you know, and we're not going to spend the first about 20 slides or so to give you some information about blended families. And sometimes we all tend to think that, you know, it's a blended family, but they come in different varieties, and they can be quite different. And the slides, I hope, demonstrate that. We're going to talk about how do you work with a blended family couple, and the joint versus separate representation issue. We're going to talk about the initial meeting. You go ahead and move the slide, Marty.
Just a quick comment, Paul.
Sure.
Everybody needs to also keep in mind that we still have a very high divorce rate in our country. I don't know if it's the 50% figure that's often talked about, but be mindful that most of the clients that we all see, certainly my client base, tends to be much older, and gray divorce of those 55, 60 and older is burgeoning. It's the fastest growing, and it may even be the only age cohort in which divorce continues to rise. So we need to be very mindful that even clients that we feel are an intact family may soon be blended. Paul?
Yes, that is an excellent point. You know, and for subsequent marriages after the first, the divorce rate is actually higher, and significantly high.
75%.
It's second marriages is about 60%. Third marriages, it's almost 75%. So once you've hit number 2, the chances of you having number 3 increase, and then they go up from there. So we're going to talk about Jonathan.
I had one couple out in California. It was his second marriage, but her 8th. And that one ended by death of him, but she remarried and got divorced again. So she had 9 divorces. It was quite extraordinary.
Well, that falls into the category, Jonathan, of my eat, drink, and remarry class of blended family client. I had actually one client, Jonathan, who married 8 times. I did 4 prenuptial agreements for him. Each spouse got younger and younger. His burying spouse was 26, which he married when he was 82. So yes, that is not unusual. Some people said that I perfected my prenuptial agreement with him because I had to write 4 of them for him. But we're going to talk about conflicts of interest. We're going to touch on some practical, particular situations in planning, and then if we have time, go through 2 decisions that certainly speak to some of the difficulties, the ethics difficulties for lawyers and others who work with blended family couples. Marty, why don't we go ahead and shoot through?
One quick comment. Keep in
Sure.
mind, everyone, that even if you feel you've addressed the conflict issues at the outset of the relationship, what I find is, and Paul said it earlier, these relationships are incredibly complex. You can't make assumptions, but they also change significantly over time. So you need to be mindful throughout the representation process of the issues of conflicts, and you need to rethink it and revisit it as you go.
Right. I think if you go ahead, I think it's slide 24 or somewhere in there, where we get into separate versus joint representation. Are you going to go to slide 24, Marty, or thereabouts? But the next subtitle, right there. There we go. All right. Obviously, you know, as lawyers, there are basically 2 ways that we can represent people, and I was looking. Really, the 2 ways are the husband and wife, or wife and wife, or whatever you're dealing with on the marriage side, can be joint clients where you really can't keep secrets, or you can treat them as separate clients. And I wanted to point out something, and I'm going to ask Jonathan a question, and I know he's going to know the answer to it. I point out a difference between the 4th edition of the ACTEC commentaries on the model rules of professional conduct, which, if you're not familiar with them, you should be. They are absolutely unbelievably good, and now they have a whole separate annotations of cases and ethics rulings. But there's a difference between the 4th edition, which is from 2006, where it contained the sentence in bold in the penultimate bullet point: some experienced estate planners regularly undertake to represent husbands and wives as separate clients. But that sentence was removed from the 5th edition in 2016. Jonathan, what changed between 2006 and 2016? And I'm thinking of one thing in particular.
Well, Paul, what are you thinking of in particular?
It happened in 2012, Jonathan. You will probably remember. All right, I'm not going to keep you. One of the biggest proponents for the idea, which I was never comfortable with and never did, was treating a husband and wife as separate clients. I just, you know, I could never get my arms around and get comfortable with that concept. But my former New Orleans colleague, the late great Ed Benjamin, was a big proponent of that. And in 2012, Ed died. And I wonder if that sentence, because, you know, he was a pretty tenacious guy. And I wonder if his death made it easier to remove that sentence. So I'll leave it at that.
Well,
but
my understanding, Paul, is that a lot of pushback on this, suggesting that you treat the husbands and wives as separate clients. And, you know, there are some lawyers, as you know, who will not represent both spouses, even in a 50-year first marriage with children only from that. They feel there still can be conflicts because the wife may want the property to pass outright and the husband wants it in trust, or the husband wants the males to have more control than the females. And husbands and wives, as we know, don't always see eye to eye on this. So the attorney is always in a position of compromising. And yes, I used to represent husbands and wives, but I would make them sign, and I'm sure we're going to get into this, Paul, a letter in which the spouses acknowledge that there could be a conflict. And if it becomes a serious conflict, then we may have to resign from representing both of them. Remember, the emotions are very, very high when dealing with family members. And this is even in a first marriage situation. And there are attorneys even today who will not represent the husband and wife together. That's, for example, I've had a number of people that I've known since I was little who came in and asked me to represent both of them in their divorce. And I would just refuse to do it, even though one said, you can represent him. I'm going to waive any conflict. I simply will not do it. It's just fraught with so many problems, you don't dare do it. But the majority of attorneys in the United States, and I was one, and I believe Marty is one, will represent both spouses in a marriage, even in a second marriage situation. But Paul, as you're going to get into in describing things with a blended family, that becomes much more difficult to do from an ethical perspective and much riskier from a liability perspective for the attorney if the attorney is going to represent both spouses. And by the way, keep in mind, it may not be a husband and a wife, it may be two wives, or it may be two husbands. So exactly. That's something else to keep in mind.
Exactly. And in fact, that is another one of the 6 archetypes of blended families that's in the slides. And there's Jonathan's point here on slide 26 about some people won't represent a couple in any marriage, and certainly more so if they are in a subsequent marriage.
Let me just add a quick comment, because this is being recorded and I don't want anyone to incorrectly infer a standard of practice. My experience is that the vast majority of practitioners, and frankly, I don't know anybody who won't represent a couple unless there's a significant issue. So I do believe that it still and remains the norm for practitioners to represent both spouses, partners, etc. So go on.
And I agree with that. I think that's and there are reasons for that, and we'll get into those in a minute.
As Paul is going to get into, you really run a big risk. I had a couple out in California who came in and they wanted me to represent both of them. But when we came down to the disposition of property, when they both died, they had different views. And I then said, I'm ending this meeting. I'm not going to represent either of you. They came back the next day and said, you can represent the wife. You don't have to represent the husband. And he said he had another attorney, and they announced that they would waive any potential conflict. So I did wind up representing just the wife. By the way, 6 months later, as I forecast, they got divorced.
That happens. But I believe that we should always be guided by what's in our client's best interest and what's in their long-term best interest. Because I believe that if we look after their long-term best interest, our best interest as advisors is going to be looked after as well. So, we just have to think of it as, what's in their best interest. Is it in their best interest for me to work with both of them? And, quite often, we all want to say yes, but, there are times when we need to really think about whether yes is the right answer. You can go to the next slide, Marty. As I mentioned, representation, joint representation has a number of benefits. Cost savings. I mean, you've got synergies. You've got people being treated as partners rather than as potential adversaries. And then you've got the integration that joint representation often brings. But with the benefits come some downsides. You can move the slide, Marty. And I think one of the biggest is this: there are situations where the spouse's interests aren't identical and they can't be safely treated that way. And one of the big examples, and in a case included in the materials that we'll talk about, the Smaldino case, The gift tax returns are not, they're not like joint income tax returns. There's no such thing as a joint gift tax return. And you say, well, we have portability, but well, portability only applies if the couple, one of them dies while they're married. What happens if, that's not the case? So portability is not a cure-all here. In fact, it's not even a substitute. So when you have separate gift tax returns and you have transactions where, as in Smaldino, Mrs. Smaldino filed a gift tax return, and then Mr. Smaldino files a gift tax return. Mr. Smaldino's gift tax return got audited, and then 8 years after or 7 years after the return was filed, the tax court said, well, the gift didn't really come from Mrs. Smaldino, it came from Mr. Smaldino. And then the question becomes, what happened to Mrs. Smaldino's applicable exclusion amount? And there's no procedural way to fix it, and it's too late. So then you have a big problem.
Couple of quick comments. If you want,
Sure.
if you want more background on Smaldino, on the Peak ILS and Schenkman Law websites, there's a entire webinar that Jonathan and I did just on the Smaldino case. It's riveting, and I encourage you to take a look at it. Here's another quick point.
Bob, well, let me add to that. Bob Keebler and I also did one on the case.
Oh, yes.
For Lineberg, and we actually get into this issue about the ethical potential ramifications of a situation where the planning was potentially integrated, but possibly one spouse's interests weren't adequately protected. So.
Another very quick point. If you're doing non-reciprocal slats and there's a time pressure and they have to be done quickly, consider the possible benefits of having one spouse represented by another counsel. It gets much harder for the service to argue there was an integrated plan and that the trusts are reciprocal if each spouse was represented by a different attorney.
Well, I will tell you this, Marty. I'm actually writing an article for the Probate Practice Reporter right now on that issue, and my take on it is probably much more conservative than yours. But the Grace case, everybody wants to focus on the tax court memorandum opinion and forget reading Grace. But Grace talks about the Supreme Court, the United States Supreme Court, talks about an integrated plan. And I believe that if one lawyer represents a husband and wife, and the plan is to create two trusts that look kind of alike, but they're not identical, and there's got enough separation in them, you think, to not be reciprocal trusts, I think you lose under Grace. I think you lose under Grace.
Let's not get too sidetracked with that, because we want to stay
and I agree with that. Okay, let's move on to separate representation.
One second, just for the record, folks, I don't agree with what was just said, but we're not going to go into it on this program. Let's go on, Paul.
Okay. In separate representation, we have, a client can freely speak to their lawyer and not worry about the ramifications of, being within earshot of their spouse who may vehemently disagree with them. And I think we've all sat through client, spouse meetings where one spouse does all the talking or makes all the decisions. And that used to greatly concern me. And I'd always try to rope the other one back into the conversation to sort of empower them. And sometimes you get pushback from the person who wants to be in charge. But that's a situation that you have. I think it reduces the potential for challenge, but it doesn't eliminate it. And I think the Sindel versus Gibson, Dunn and Crutcher case, discussed in the materials later, is an example of that. It doesn't eliminate the risk.
Let me just highlight and emphasize what you just said, because I think it's incredibly important. We all see lots of couples where one, and it's not necessarily the male, one of the two spouses or partners dominates everything. And I do exactly what Paul said. I will look at the other spouse or partner and talk directly to them. After a long soliloquy by the dominant spouse or partner, I may look at the other spouse and partner and say, what do you think? I make sure you address all communications to both of them. And I'll tell you where you get into some trouble with that. Send the bill to my business. My business will pay your bill. Be very careful with that.
Yeah,
Paul?
and also, Marty, and that those are excellent points. But don't just listen to what the other partner says, or the discounted partner. Don't just listen. You know, they may say, "Oh, it's okay." Watch the body language, because quite often the body language is telling you something different from what the words are. You know, they don't want to create waves with their partner, but their body language is clear that I don't agree with that. I'm not comfortable with that, and I don't really want to do that. And that's why you have to really look at them. You can't just listen to them. You need to see them, and you need to read their body language, because quite often that is what's screaming at you. No, I don't agree with what my partner just said. So you can move to the next slide.
Another comment. Jonathan and I did an article on the Wellen case, a recent malpractice case where there was certainly some family dysfunction in a blended family. You need to be very mindful of what Paul said. And my recommendation, I'm not saying it's a standard of practice, but my suggestion is put stuff in writing. If you send a letter to both spouses and you document the pros and the cons of a decision, I think it gets harder for either spouse later to say, gee, you didn't tell me. Jonathan, do you want to make a quick comment? I know it's a sidebar, but it is important on Wellen and how people should protect themselves in blended families.
Well, yes, I mean, let me just briefly go through the facts of Wellen. Mr. Wellen was an older man. He was in a second marriage situation. Basically, his lawyers, who had represented him for a long time, suggested he do an installment sale to a grantor trust, a so-called note sale, which he did. And he got back a note. He sold the property for about 100 million, and the note he got back, according to the court, was worth only about 50 million. Now, that should have been a home run from an estate planning perspective, because the discount on the note compared to the value of the property transfer. And Mr. Wellen did that, but along the way, the assets he had sold to the trust were sold, and because the trust was a grantor trust, the capital gain was all attributed to him. And he wound up not just terminating his representation of the law firm, but he also wound up suing the law firm. And along the way, his wife was on the stand, and she said she really said very little. It's a second marriage situation, but the beneficiaries of the sale of the property on the trust that had made the purchase were his children from a prior marriage. Now, what Marty and I have wondered about is the Fourth Circuit. This is a federal case, although it involved New York state law. Probably because of diversity of citizenship of the parties involved. But the court said no one wound up paying the tax, although Mr. Wellen claimed that he had been practically ruined because he had this huge tax bill, and he had a very famous estate planner, Jerry Hesh, come in and testify on his behalf. But the bottom line is the Fourth Circuit said no one ever paid the tax. So the question arises, why did they complain? They never paid any tax whatsoever. It's a super grand slam as far as an estate planning perspective. I suspect, and I think Marty agrees with me, it's because the second wife didn't like the way that the properties were disposed of. They were all going to go to his children of the first marriage. And she and her children from her first marriage didn't participate as fully as she thought she should. At least that's what I anticipate was the basic problem. But it goes to show that you can do the best estate plan in the world for someone, but you've got to consider collateral effects, like what about for the remaining family members, especially if there is a spouse from a second marriage And therefore you have basically a conflict where that spouse, even if he or she has signed a prenuptial agreement, which you probably should recommend to people whenever they're entering a first marriage, if not a second marriage, if not a first marriage, need to acknowledge what's going on. As Marty said, put it in writing, put it to both spouses if you're representing both spouses. Don't forget to do that, because otherwise they're going to come back and say you, the attorney, didn't live up to what you should have done for both parties.
Exactly. And I couldn't agree more. And grantor trusts and the Milstein case out of Ohio really, pointed that out too, where, sometimes grantor trusts work so good that it becomes painful for the grantor in that case. Now, if you've got a couple who want you to represent them jointly, there may be some signs that may not be in their best interest, despite what they're telling you they want. And I've got a couple of points here, and I want to hear you guys' comments on them, where you have one partner who has no children at all, but the other one does. One where one partner does all the talking or seems to exert control. If the relationship isn't very long, if the couple or one person, one of the spouses has had many relationships, and then if there's an age disparity. What are y'all's thoughts about those?
I would add two more to the list. I would go beyond.
Well,
just
actually, it
age
goes on to the
disparity.
next slide, Marty.
Oh,
So it may be
I'm
covered.
sorry. Okay, you got me.
Is it
The
there?
comment I was going to make is it's not just age disparity, but really almost any type of significant disparity that just seems concerning. And I think you don't want to limit it or define it, but just be observant to what's going on in the relationship. Paul?
Well, one that just occurred to me that's not here, that I seem to recall this having been a potential issue, is cultural differences, where one spouse is from a different culture that has different societal norms than the other spouse. And in a situation like that, you may have that disparity in power. You may have, and then there's economic dependence. But one I really, and I expect some and I know I'm going to get pushback from Marty on this one. But I have always believed that if a couple if they came to me to represent them jointly, and they had a prenuptial agreement in which they were separately represented, I never represented them jointly. Never did. Because one truth about prenuptial agreements is it's one of the most hotly contested agreements in the law if the couple gets divorced. I mean, there are some divorce lawyers who it's just knee-jerk pleading, immediately move to invalidate, especially if it's against their client, invalidate the prenuptial agreement. So you don't know that the agreement that they have is actually going to stand. And because quite often they are challenged. So that's one of the ones that when I saw it, and now I'm going to let, because I know Marty has a different feeling, and Jonathan probably does too, but I'm a belts and suspenders guy. I'm sort of a Justin Wilson guy. So go ahead.
Yeah, I wouldn't not represent a client because they have the couple has a prenup. Rather, I want to look and focus on all the other factors that Paul has talked about. If it's a cohesive partnership and we're not violating the terms of the prenup, I don't see a problem representing them. But very frequently, what happened in my second marriage. We years later, you kind of begin to disregard what's in the prenuptial agreement. I mean, at that juncture, what I do is I tell them in writing to go back, hopefully in writing, but I certainly tell them to go back to their respective matrimonial attorneys and modify the prenup, because at least then they're represented by a separate counsel in making a change to what they're doing. So I think the facts really depend on what they're doing and how they're doing it. But if it's already been a decade and longer since the prenup, you'll find many clients are going to change what was in the prenup. Very common. The most common thing is, you know, if they got married with a prenup and then later had kids, and then you know, the wealthy spouse, whichever one it is, now after they have children wants to leave more to the unwealthy spouse. Very, very common. So I don't know that you have to not represent them, but I do think that Paul's caution is important to keep in mind, and you should consider how you document it and at what juncture you may suggest that, well, for those issues, folks, you need to get separate counsel.
Let
I want
me
to hear
add
from
one.
Mr. Blottmacher on this.
Yeah, well, I look at this a little bit differently than Marty does, because one of the things that may happen, and I think the only one I've ever seen who put this in, you have a prenuptial agreement in which you're going to limit what the other spouse gets in the event of a divorce or what the other spouse gets in the event of death. Very common provisions in there. But they decide they've lived together for many years. They maybe even have a child together, even though one or both of them may have descendants from a prior union. But they come in and they say, look, I don't want to limit my spouse to $1 million or 10%. I want to do kind of a standard plan where I'm going to use basically an optimum marital deduction and put the balance in some sort of credit shelter trust. And ultimately, everything will be spread among all the children. So the kids of the wealthier spouse all of a sudden come in and say, wait a minute, that prenuptial agreement was supposed to give me rights as well. It's the equivalent of a third party beneficiary contract. And don't laugh at that way. That's preposterous. It's only between the husband and wife. But unless you expressly state that this is in no way a third party beneficiary contract to benefit children from either marriage, or even if they have one jointly, or anyone else, you're going to be saving yourself a lot of trouble. Because I'm going to tell you, if I was supposed to inherit $50 million from my dad, but it wound up I get a lot less, then you have a real problem. Also, think about, what do you say to the spouse? The spouse, you do a will, you follow the prenuptial agreement exactly. But do you have a duty to tell either spouse, you know, even though this prenup says you only have to leave Marty 10% or $1 million or whatever it is, please understand, Jane, you could always ask for more. Marty, do you want to give more? It really complicates things, because you're now taking a position as to whether or not that prenuptial agreement is valid or not. As Paul indicates, you may find that many prenuptial agreements will not stand up. And I've been in cases where I was confident that it would not stand up in court. Like one case, the couple had dated for a couple of years. She insisted they get married. They put the marriage together very, very quickly. And as they are at the church, just before they both got into their second marriage, her lawyer came in and said to the to-be husband, the fiance, sign this prenuptial agreement. Well, I told both of them I did not think that that was going to be enforceable. And I made each of them get separate lawyers to advise them about that. Now, all worked out in the end okay. But he had a daughter from a prior union. She had 3 sons from a prior union. And the kids from her and the daughter from his didn't get along that well. So this is a very, very dangerous area to work in. Please make maximum disclosures. But again, you've got to think about, for example, let's say the husband has a pension plan, and they decide that they want to do something other than provide for him to get a life, basically, interest in that plan, and then it go to the wife. Well, under the Retirement Equity Act, you have to have the spouse accede to it unless he or she waives that right. Well, you may have a great plan. They've gone to Marty, and Marty says, look, we can avoid all the estate tax and income tax if we do this, but it means that you're not going to have a life annuity followed by a life annuity for the other spouse. Well, do you raise that and say, this would be great, but Marty, you've now got to waive your rights to Patty's pension plan. Well, can you tell him that, even though at the moment it looks good? I really question whether or not you can do it. Again, put it in writing many, many times. And certainly when you're asking someone to give up marital rights, they have to have separate representation. In fact, I've even made them get separate representation, even in a first marriage situation. I recently had this happen for a very wealthy couple that I represented out in California, and where I am trustee for the family, for the husband and the wife, even though it's in a first marriage situation, I made them each get separate lawyers when they went in and waived certain rights, including converting community property into separate property, which could be used more efficiently in estate planning for the children. But I insisted they get independent representation.
Well, those are obviously excellent points, Jonathan, and particularly the third party beneficiary line. I mean, that's worth that makes listening to this whole program worth it by itself. So if you have a situation where I think at a minimum, and I think Marty would agree with this, I think you have to look into the details of how the prenuptial agreement came into effect and how it came into being. And if you determine that it was signed, with a shotgun in hand at the church, on condition of this marriage going forward, you will sign on the dotted line. That is a prenup that, as Jonathan pointed out in his situation, I'm not sure that I would bet the farm that one would be upheld if the couple got divorced. In fact, I would probably, if I was a betting guy, and I'm not, but if I was, I would bet the other way. So
I've seen that.
Well, let me add one other thing I did. I would have a couple, say you're going to first marriage and they're going to sign a prenuptial agreement. And by the way, friends, let me tell you what I did. And one of my wealthiest clients said it was the best thing I ever did for him. He made his big money a little bit later in life, and his kids were all in their early 20s and he got married. We began to create trusts to do as good estate planning. And in those trusts, we put down that no grandchild or more remote descendant could ever receive a benefit from this trust and would have no power of appointment over that trust, which permitted them to continue part of the trust in trust for their spouse, but only if they entered a prenuptial or postnuptial agreement, which independent counsel on behalf of each party agreed was sufficient to protect their financial interests. Now, in one case, and I was having the granddaughter of a billionaire marry a guy who was, kind of a middle-class fellow like me. I insisted that he get separate representation, and he and his lawyers certify that he was not acting under a compulsion. Because when he originally got his lawyer, the lawyer called me and said, Jonathan, very happy to work with you. By the way, I'm going to take the position that this man is signing this prenuptial agreement under duress. And I said, well, guess what? Your client is never going to be able to receive anything, nor is his wife going to receive anything, because I have to determine whether or not this is sufficient to protect her financial interests. And I can't conclude that because you're saying that your client is going to say that he acted under a compulsion. Well, about a week later, I got a letter from him signed by his lawyer in which they acknowledged that he was not acting under a compulsion. Now, could they have come back in 5 years and said he really was? I don't think so. He had an independent law firm as big as Milbank Tweed representing him, and I got the lawyer to certify and the client to certify that he was not acting under a compulsion. And by the way, if you're dealing with prenups, don't have it signed just before the marriage, because that's when they'll say, I was just under a compulsion. We put all this stuff together, our parents, our grandparents, our friends. We just had to go forward with the wedding. We just would have been horrible not to. And I only signed this prenup because I was acting under a compulsion.
I know, Jonathan, that the interactive legal documents contain that language for basically marriage contracts, and there's a treatment there, and obviously that is a great idea. When you're talking about interpreting wills and trusts, obviously on the death of a spouse, if there is a prenuptial agreement, you've got to interpret it. And in that interpretation, you've got to consider whether it would be upheld, particularly if it didn't give the other spouse enough to cover, to prevent an election against the will. Another issue that often arises in community property states, or even in common law states, if a couple has commingled property, and it's basically bled out of their separate property into the community, or maybe from their separate property into jointly held property, but it really wasn't intended to be a transfer. You have those issues that come up all the time, and you need, and I think that when you're representing people whose ultimate beneficiaries are not the same, and in blended families that's usually the case, these are issues that just take on more importance than when it's a one relationship couple who have children that are only joint children, or descendants that are only joint descendants.
Let me squeeze in two quick comments, Marty. Let me squeeze in two comments. Commingling is almost inevitable. Unless the money is segregated, the assets are segregated in a trust or entity to differentiate them, it seems that commingling almost inevitably happens. And that can undermine the best laid plans. So very important to warn clients about the issues of commingling. And I think one of the reasons commingling doesn't get addressed in practical terms is because even if it's all provided for properly and thoroughly and perfectly in the legal documentation, how are their accounts set up? How are they spending money? Who talks to the clients about that? And I find in a lot of cases, none of the advisors are really addressing that. So one of the common things I've seen in prenups is separate property of one spouse, let's say an investment account remains separate property, but the income is going to be marital property. How do you define income? How does that count administered? It always ends up getting commingled. A simple way to address that, and I'll stop with this one example, but I just want to illustrate the point, is you tell the couple, listen, if the corpus is going to be separate, then have the account structured where there's a marital, let's say, checking account at the same brokerage firm, investment firm, and every time a dividend or interest comes in, assuming that's how income is defined, it's transferred into that account so that you don't end up with an automatic commingling. Another quick point, if you do an estate plan for a couple that's got a prenup, have a financial advisor do a forecast showing what happens with your estate plan. If the planning results in one spouse not having enough resources to support their lifestyle expense, and I've seen that in a lot of cases, you're going to have a problem even if you've done everything right. Because what's going to motivate somebody to sue anything more than if they can't pay their lifestyle expenses? So make sure that you go beyond just the legalities and address the practicalities. Paul?
Yes. All right. Some other conflicts areas. Non-reciprocal will provisions where one spouse is a fiduciary but the other is not for the other's plan. When you get into equitable interests and quasi community property, you can go to the next slide, Marty. And the bottom line, and here's a reference to the Welland malpractice case. I think the biggest thing that planners should remember is that your client has tough choices, and quite often the blended family client often feels that they're faced to choose either between their current partner or their descendants from a prior union. So then that tells us as planners that it's important to be aware that the client has these tough choices, but we need to protect ourselves too, because we're vulnerable parties in this situation, and often our malpractice or E&O carriers, are looked to as piggy banks in these situations. So you got to consider the whole family system when you're dealing in this area. You can go to the next slide, Marty. The initial meeting, I don't want to spend much time on this because we're running short of valuable time. This has been a wonderful discussion. But there are a number of ways that a couple can come to you. And what I'm going to suggest to you is what your relationship is with either of them before they became a couple matters, especially if they eventually separate and divorce. So you can go to the next slide, Marty. And then you wonder, how you should meet with them. And go to the next slide, Marty. I think
just
that
a quick comment, Paul.
Sure,
in a virtual age where you're meeting virtually, it's a lot tougher. When we in the old days pre-COVID, when all our meetings were physical, it was very easy to meet with the couple together in the big conference room and then ask, one spouse to meet with me separately in a different conference room. It gets kind of hard to do that when you're all on a Zoom call together.
And on slide 38, I used to have a procedure that I used to use for this. And I would sit down with the couple. I said, this is one engagement, and I'm going to figure out whether I can work with you jointly. And I would talk to the couple together and in the engagement, part of the scope of work was to include a private conversation with each spouse. And if I compared notes of the private conversations and they differed, and sometimes they did, I would nope, I'm not going to work with you. And I made it so I didn't have to tell them why, because that was built into the first engagement letter. And then if I determined that I thought it was safe to proceed, the second engagement, the actual estate planning engagement, happened. So I think that, once again, being defensive. Go ahead. You can go to the next slide, Marty, because we're going to now get into the conflicts. This is just talking about the fears of estate planning. In my book about yours, mine, and ours, estate planning for couples in blended or step families, I identified 12 distinct fears that clients have in estate planning. And estate planners usually think there's only one fear: the client's worried about their own mortality. But there's actually 12. And we don't think about that, but there actually are. The result of fear is often procrastination, and people think, they just don't want to deal with their own demise. But it's much more, it's much deeper than that. It's much psychologically deeper than that. It's not just mortality salience. Why are blended if you look every year, and every year Dana Fitzsimmons does a wonderful program at Heckerling on the state law cases. And if you look behind each of those cases, you'll see that an inordinate number of them, because I go looking for these cases, especially in the blended family area, are involved blended families, like the Welland case that y'all discussed. And you say, well, why do blended families have so much angst? And the bottom line is quite often it's fear, and then there's anger. Because there's fear. The fear is the base. The anger is just the outward manifestation of it. And people are fearful that they're going to lose what they may think they're entitled to. And sometimes people are grieving. They're grieving the loss of a parent, or they're grieving the loss of their parent's relationship. And then all of a sudden this interloper comes in, and the kids, they don't know what to do with that. And all their default is protect their interest, and that becomes an adverse situation. So that's why in the end, Mark Twain was right. you never really know someone till you share an inheritance with them. And quite often these families figure that out when the first spouse assumes room temperature, and then everybody lawyers up and ends up down at the local probate court. You can go to the next slide, Marty. And you can skip through this. I want to get to some of the conflict stuff because we're almost out of time. And Jonathan was right earlier about, we have a lot of material here, and we're never, we couldn't get to all of it. But conflicts are problems, and they're usually bigger in hindsight than they are in front of us. My ethics professor at LSU Law School, the late Warren Mingus, used to say, in a free case, a lawyer can spot a conflict a mile away. But in a fee case, that conflict may sit on the bridge of the lawyer's nose and the lawyer misses it. So that was, I always thought that he was right about that. You got to look out for not only actual conflicts, but potential conflicts, because they always make you look worse in hindsight, which is always 20/20 than in fact. Go ahead. I tell you what, because we're really at the end of our
we have 15 minutes, Paul. Paul, we have 15 minutes.
All right. Well, the model rules, and I know Jonathan can stay on, for a short time. Go to the next slide, Marty. Go to the rule 1.7. Here we go. The general rule is you can't represent people with a concurrent conflict of interest, and the definition there is set forth, and I laid out the elements, and you can represent someone with that current conflict of interest if you have a reasonable belief that you can provide competent and diligent representation. But the final point, bullet point 4, they have to give informed consent. Go to the next slide, Marty. And concurrent conflict of interest, the first one is easy if they're directly adverse, if they're actual parties, it's, Penoyer versus Neff. Penoyer and Neff are adverse. So you can't represent Penoyer and Neff in the same matter. But the or is the problem, and it's a big or. If there is a significant risk that your representation of simultaneous people will be materially limited to not only your responsibilities to another client, but potentially to a former client or a third person. So you got to watch out. And people say, well, I got that covered, Paul. We have waivers. Go to the next slide, Marty. Well, informed consent, you've got to give certain information, and the comments to model rule 1.7 say that the conflict has to be consentable, which should be a red flag for us all, because not every conflict is consentable. I mean, for example, I think an easy one is you can't represent a husband and wife confecting a prenuptial agreement, or two betrothed people putting together a prenuptial agreement. In fact, in some states, that's expressly against their model rules. They've actually put an express provision in their version of Rule 1.7 that says you can't do that. But not every state does. But the model rules definitions or the comments, say that not all conflicts are consentable. And then sometimes you've got the situation where the conflict is so convoluted that you might have to send the client to a different lawyer to explain it to them. And then you've got, the matter Jonathan's licensed in California, where they have to get the certification from separate counsel in some situations. So here we just have some of the modern conflicts. Yes.
Paul, that is so critically important. I mean, there are some cases with a husband and wife where you just cannot waive the conflict, when you know, like the case I mentioned where the couple came in, it was obvious that he was just going to make her do it the way he wanted. And that made me say, I will not do the representation. By the way, she never came back to me until about 6 months later, and exactly what I told her would happen, happened. It was the only topic of conversation. You've got to sign this prenuptial agreement. You're going to get nothing. You waive any community property rights, and I'm going to leave it all to my kids and not to you. And she didn't have any kids from any relationship before or during that marriage. And again, I wouldn't do it. Well, she came back 6 months later, and he would not let it alone. He was like a dog with a bone. She signed the prenup, and 1 week later, he left her. So I told her, because I'd been involved, I couldn't represent her, but I had her hire another lawyer who brought a suit to declare the prenuptial agreement invalid. I was called to testify by the judge, who complimented me on what I did, by the way. He said, Jonathan, this is a judge in a trial where I said what I had done and why I wouldn't represent and so on. And I told her after I found out that he had berated her. It was the only topic, lunch, dinner, night, nothing but you've got to sign, you've got to sign. And ultimately she did. And sure enough, when I knew what happened, within a week he left her. Why? Because he had another girlfriend. So
What a shock.
you've got to be aware of this. You've got to be very, very sensitive that one spouse may be so overbearing on the other. Like my wife is from me, Marty. You know that. Betsy just controls me terribly, all 90 pounds of her. And again, if Betsy had me, so I think, in fact, most of my property is in Betsy's name. So I probably, Marty, have a good case to bring if Betsy runs off with you, which I'm worried she may do. By the way, she said the other night when we were at dinner together, she said, he's a very handsome man. How about that, Marty? So, what can I say? Don't fall into the trap. Don't think you can make it all right. Protect yourself first. And as Paul said, if you do the best job for the client, you're doing the best job for yourself.
Let me just interject a quick comment. It gets very tough. We've talked, when we're using examples, we use kind of obvious examples because it illustrates the point. The reality is that in a lot of these cases with blended families, it takes time. It could take years before you start to see the fissures, the issues, the disconnects. So be very alert. Just because a client's an old, long-time client, don't put your guard down, because it may only be years into the relationship that some of these concerns arise. And the second thing that I see happen all the time is we all want to have a wealthy client. And when you have a situation like Jonathan described, you may have to let go of that wealthy client. If the worries about conflicts become too great, you have to deal with it. It's better to be safe than sorry. If you see an issue, address it and deal with it. If you have to terminate the client, terminate the client. You got to protect yourself. Paul?
Well, I have always said, Marty, that it's better to be client-less than a defendant.
Unfortunately,
So,
very true. Very true.
Go to the next slide, Marty, and we'll see how much more we can get in here. Go to the, well, I'll tell you what, the waiver of reimbursement in blended family couples, quite often, if it's a Q-tip plan in a single family relationship, the surviving spouse may well waive the 2207A reimbursement. But I can't think of a situation in the blended family where a spouse should ever do that. Jonathan, am I wrong about that?
You're absolutely correct about it. I feel that way.
Well, I mean, but you see it, because that's the way most people's documents are drafted. And if
Paul,
they're not using a Cracker Jack,
define what you're talking about.
What I'm saying is if you are using a cut and paste drafting system where you take a will plan, you're not using what you should be using, which is ILS, the drafting system, and which asks you these questions. if you just take a cut and paste from a single relationship couple, and in that cut and paste, it says the surviving spouse waives the right of reimbursement under section 2207A, which basically, you know, because of the 2044 inclusion in the surviving spouse's estate, because of the cost of Q-tip, the 2207A gives, unless it's waived, the surviving spouse's estate the right to go back and get the tax money from the Q-tip trust. But if your document waived it because it was a single relationship couple, and you've got a blended family couple where you should never waive it, you know you're in the soup at that point. So that is a real live conflict of interest, and really most of us are saved today because of the high applicable exclusion amount.
Well,
Go
Paul,
ahead, Marty.
In fact, there's a case in New York County, second marriage situation, where they put in the waiver, and the children wound up suing each other after both of them died. And New York State changed its law. It's very, very dangerous. I've always regarded as the tax apportionment clause as one of the most dangerous provisions you can have in the will. And it is one where you just don't look at probable intent. You don't just look at the words. If you want to waive equitable apportionment of estate tax, it has to be clear and unambiguous, which is very, very difficult for any of us to do. And the one thing I can assure you, do not put two tax apportionment clauses in your instruments. Also remember, you can't waive things or change the tax effects from one instrument to another unless you're exonerating it. And I think the most dangerous thing that many lawyers could do, which was the standard when I got into practice and I thought about it, where you say, pay all taxes due by reason of my death from my residuary estate. Well,
Right.
then anything that passes otherwise is going to have the tax burden on that property imposed upon the residuary estate under the will. And that means the people who you thought were going to really inherit most of your property, maybe your children, whoever are the residuary legatees, are now going to be stuck with a tax bill. It can be horrible. But
There's a great case, Jonathan, out of Colorado involving that issue. It ended up being apportionment of Colorado state death taxes, but the same law firm represented both the Q-tip trust and the trust of the surviving spouse. So you had, it's an amazing, I've written about it and I forget the name of it, but it's a, you know, and the law firm was a deciding vote. There were two trustees of the kids, of each kid, each spouse, and then the law firm was the decision maker. And you know, where are you going to go? You know, are you going to waive reimbursement? Are you going to pursue reimbursement? Are you going to not pursue reimbursement? And the case went to the Colorado Supreme Court, and it was reversed along the way, and it was really a quagmire. And I write about it in a number of places. So, all right,
we have 4 minutes. Why don't you just go through some of the specific ethical issues, then we'll wrap up.
Okay, all right. Go ahead. Go to the joint tenancies. I think this is one where in a blended family couple, if you have joint tenancy property, you got to remember that each spouse has a unilateral right. You know, I'm not talking about tenancy by the entirety, which requires joint consent, but in a typical joint tenant with rights of survivorship situation, each spouse has a unilateral right to sever. And I always recommended, you know, for clients, you know, and we didn't have much of that in Louisiana because of community property, but where you had clients who were Louisiana residents but had separate property in other states held as joint tenants, you know, I always recommended severance, really to sort of replicate the community property rights that people have. And the reason why I recommend it is you never know who is going to die first. And in a blended family, you know, we know the survivor wins in the joint tenancy situation. And I've been fooled too often. You don't know how the order in which people are going to die. go to the next one, Marty. See if we can just sneak in one more before we got to sign off. Gift splitting can be a huge issue. You know, it might be required in the prenup. And annual exclusion gifts may be okay, but suppose one spouse wants to make, you know, the applicable exclusion amount gift, and wants the other spouse to join in. And of course, you know, on the gift tax return, you know, you got to elect that. But if you do, all the gifts that year have to be split, and then that creates problems. So I think we're up against time, Marty. But so go ahead and sort of wrap us. You know, go to the end. And we have things about the marriage contracts, and we've talked about that. And then there's discussion about Gibson versus Sindel versus Gibson, Dunn and Crutcher. If you want more information about blended family estate planning generally, Marty and I did a 3-part series for Lissy, and it's there. And then I wrote a book about the subject, and that's available. And I think, Marty, I will cede back the rest of my time.
Jonathan, why don't you give some concluding comments?
I had the privilege of reviewing Paul's book, and it's really worth having. And again, you will definitely wind up representing people in second marriage situations. So it's something you really have to pay attention to.
I'd like to thank especially Paul for leading the charge on what hopefully was a very informative webinar for all of you, and Jonathan Blottmacher for joining with some great comments. And I hope this was helpful to all of you. And I want to thank all of our sponsors, Peak Trust Company and Interactive Legal, and our featured charity, the American Cancer Society. Be well, everybody. Take care.